Good evening. My name is Kristen Ike. I am the Code Enforcement Special Magistrate for the City of Deltona, and I'm calling the Special Magistrate hearing of August 27th, 2025 to order. First thing on the agenda is roll call, so I will have all of the code compliance officers introduce themselves.
Mark Gibson, Code Compliance Supervisor.
Danny Ron, Code Compliance Manager.
Sharon Shivers, Fire Marshal.
Sam Schaller, Assistant Fire Marshal.
Lisa Nadeau, Fire Inspector.
Jessica Cotterman, Hearing Clerk.
Tyler Russell, Code Compliance, Customer Service.
Renee Kearney, Code Compliance Administrative Supervisor.
Todd Mead, Code Compliance Supervisor.
Thank you. Please join me in the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Next on the agenda is my statement about how the hearing is going to proceed tonight. I am going to read this so I don't forget anything. We are here tonight because the City of Deltona has contended that there are violations of the Deltona City Code that exist. This is a public meeting, which means that no general public comment will be accepted, but each of the respondents and the code compliance officers here tonight and any witnesses each of you call will be able to present evidence to me regarding each case and the violations of the Deltona City Code that are being alleged. I am an attorney and appointed by the City Commission to render decisions in these code enforcement matters to determine if a violation of the City Code exists and what fine will be imposed, if any. If you are here for a Massey case, you might see that next to your case number on the agenda. That means that I will be determining solely whether you have come into compliance in a timely manner in accordance with the previous order the special magistrate issued in your case, and will not be reopening the case to determine whether or not a violation existed in the first instance. Any decision I make this evening will be put into a written format in the form of an order. A copy of my written order will be provided to the city and then mailed to you as well. It is important to note that for any order I issue, you may appeal by filing a written notice of appeal with the circuit court within 30 days of the execution of my order, pursuant to Florida Statutes Section 162.11. The procedure of the hearings today will be governed by Chapter 162 Florida Statutes. Formal rules of evidence shall not apply, but fundamental due process shall be observed and shall govern the proceedings. Hearsay is admissible, but only to support other competent and substantial evidence. If you are a respondent, you will be able to testify. Tell me what you think I need to know about your case. Present evidence and witnesses. Your testimony will be under oath, so I will be swearing you in, and this hearing is being recorded. For each case, I will call the case number, and the city will proceed first. The city has the burden of proving that the code violation exists. Then you will be allowed to respond. For each case, I intend to omit the case file and the PowerPoint presentation that will be shown this evening. You should have received a copy of your case file when you came in this evening. If you did not, please let me know when your case is called. But I do intend to admit the case file and PowerPoint into evidence unless a specific objection is received. I will take the cases in the order that you signed in, first come, first served. I do have a list of cases that have been withdrawn or continued, so let me announce those. The withdrawn cases are DEL 24-072, Massey case, 2912 Thalita Terrace, DEL 25-079, 725 West 9th Street, DEL 25-081, 928 Halstead Street, DEL 25-084, 1109 Eagles Nest Avenue, DEL 25-085, 1223 West Wellington Drive. Fire 018-2025 Massey, 1200 Deltona Boulevard. Fire 031-2025, 1681 Providence Boulevard. And the continued cases are DEL 25-082, 1223 Whitewood Drive, and Fire 035-2025, 1240 East Normandy Boulevard. So if you are here for any of those cases that I just read out, you do not need to stay. Your case will not be heard this evening. I will go ahead and swear in everyone who intends to testify today as a group, which includes the code compliance officers. So if, please stand if you're able and raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth? If so, please say I do.
I do.
Thank you. All right, I have no ex parte communications to disclose, and we will proceed on with the cases. All right, first case is Fire 34-2025, 114 Cortland Boulevard.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-034-2025, the City of Deltona versus Fellowship Baptist Church of Deltona, Inc. The property address is 114 Cortland Boulevard, Deltona, Florida 32738. Parcel ID is 813-060-000-010. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42 through 186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1.7.12.10. No construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. Violations B and C have been resolved prior to this hearing. Corrective action is to obtain a permit for the installation of the new shed and associate electrical or remove the shed and restore electrical to its original condition, and to contact our office with a permit number once obtained. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the Special Magistrate Clerk. I certify that any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 29th, 2025, I conducted a fire safety inspection at this address where I observed a newly constructed shed with electrical inside. The property owner was informed a permit would be required for the installation of the shed. The property owner was notified in writing of the violation, given a time frame to correct said violation. Subsequent re-inspections on April 1st, 2025, May 12th, 2025, June 6th, 2025, June 24th, 2025, and August 4th of 2025 found no progress on the noted violation. Upon today's site visit, the shed remained in place. The city would like to request 90 days for this property to come into compliance with the remainder of the violations or a fine of $50 per day until such time that the property owner has notified the city of compliance.
All right, thank you. So just a question, are there multiple sheds or just one?
There are multiple sheds, but that's the newest one that we have no
Okay.
permit for.
So the others have a permit, is what you're saying?
The other ones are older sheds from way back, and we don't have records for those.
Okay,
So
all
that's why I
right.
said A and B were, or
Okay.
B and C.
Okay, and so what we're focusing on is the new shed that was
Yes.
installed. Okay, thank you. Sir, can you state your name and address for the record? I'm not sure that it is.
My name is Robert Arnold, and I'm the chairman of the Board of Trustees for Fellowship Baptist Church.
All right. What
Excuse me.
what would you like to tell me about the case?
Well, the three sheds have been there for a number of years. The first two that are not in question at this time have been there in excess of 15, one of them 22 years, I believe. They were probably installed by members of the church. The third shed went up, I think, about 6 years ago. And again, it was done by members of the church. Excuse me, it took quite a bit of time in discussing things with Chad Tate, with the permitting department on all of these issues, and I think we finally got them resolved by getting a permit. I don't have the permit yet, but the application was taken for a permit to have the shed in question removed and the electrical capped.
Okay, so you're proposing to remove the shed?
That is correct.
Okay. All right. And that permit has been submitted already?
The application is in, yes, ma'am, but the permit will not be ready until tomorrow morning.
Sure, okay, all right. Anything else before I make the ruling?
No, ma'am, I can't think of anything.
Okay, all right. I'm going to go ahead and find a respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on, that would be November 25th, which is 90 days, so hopefully that's plenty of time to get the work done. So November 25th of 2025, and in the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm admitting the case file and PowerPoint as exhibits into evidence, and I find the notices properly given in this case. So, sir, please stay in contact with Ms. Nadeau to let her know the status and when you've come into compliance.
Yes, ma'am.
Thank you.
Thank you.
All right, the next case is Fire 032, 2025, 1310 Maximilian Street.
Good evening, Your Honor.
Good evening.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 32, is 2025. City of Deltona versus Thomas G. Wensky and Bishop Diocese of Orlando. Property address is 1310 Maximilian Street, Deltona, Florida, 32725. Parcel ID is 812-901-020010. It's a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1 Fire Code, Section 13.1.8, which states all fire protection systems and devices shall be maintained in a reliable operating condition and shall be replaced or repaired where defective or recalled. Corrective action for said violations is to contact the fire alarm service provider, correct the deficiencies noted on the April 11th, 2024 and October 15th, 2024 fire alarm inspection reports. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. Certify any and all photographs to be true and accurate portrayals what was observed on the day they were taken. April 9th, 2025, while conducting a follow-up to an initial fire inspection, Fire Safety Inspector Jory Bailey received 2 fire alarm inspection reports. One was dated April 11th, 2024, the other October 15th, 2024. Both listed numerous deficiencies with the fire alarm system. The property owner was notified of these deficiencies, requested to contact their fire alarm service provider for repair. Subsequent follow-up inspections conducted on May 14th, June 30th, July 28th, 2025, found no documentation of completed repairs have been provided. Closing, the city would like to request 30 days for the property to come into compliance with the violation, or a fine of $50 per day until such time that the property owner has notified the city of compliance.
All right. Can you just, is it possible to briefly describe what the deficiencies consist of?
Yes, Your Honor. You'll see them both. Exhibit B will be the most recent fire alarm inspection report. If you'd like to read along.
Yes.
Right here on Exhibit B, right on the almost to last page. They've got a list. It has 5 items. North Slope Center Sanctuary is labeled as Vice 16. Another smoke was improperly labeled. 1 smoke detector needs to be remounted. The key lock to the main fire alarm panel is broken. And there are 2 heat detectors that were not tested because of no access. They're also too close to AC vents. And then Exhibit C also has a few other items outlined. On the 3rd to last page, a few of these items are repeats. Has 2 smoke detectors that are mislabeled. Another duct smoke detectors falling off of the ductwork. 1 air handling unit did not shut down upon activation of the duct smoke alarm. Northeast duct detector is not mounted properly, loose on the ductwork. Key lock to the main fire alarm control panel is broken. South air handler mechanical room had multiple junction boxes open. In general, none of the exposed wiring is secured by code. Wiring is just draped over mechanical equipment. Northwest and west sanctuary duct detectors in return ducts do not signal to the fire alarm panel. 2 heat detectors at 22 feet in center of sanctuary were not tested due to no access, too close to AC vents within 36 inches.
All right, thank you. Sir, can you state your name and address for the record?
My name is Robert Urrutia, Urrutia. I'm the business manager for Our Lady of the Lakes Catholic Church at 1310 Maximilian Street.
Okay. What would you like to tell me about the case today?
Everything is working properly. The fire alarms, the detectors up in the ceiling have been moved. Everything that they said was hanging out or loose has been repaired. We do have one little issue that's going to be fixed tomorrow, and I do have a copy of the work order that the ceiling was done, and I also have a copy of the billing that I'm getting. The smoke detector actually does work, shutting off the system. The problem is it was only shutting off the fan, which I know is not fully operational because the AC unit was still kicked in, but it wasn't really kicked in because the calibrator or whatever all the electric part goes into the AC unit, malfunctioned. So tomorrow they're coming out to fix that, and we're getting re-inspected on Friday.
Okay, so, and that reinspection would cover the other things as well that
Yes.
you say have already been repaired?
Already been done.
Okay.
J&J Security, our company that has done it, they did actually most of the work.
Okay.
I don't know how their company works, but they're the ones who inspected, and they're the ones who had to come and fix it, and except for the AC unit, which is going to be repaired tomorrow.
Okay. It sounds then that the 30 days seems like it would be a reasonable time for you to wrap this up. It sounds like.
You should have a copy of the report Friday afternoon.
Okay. All right.
Otherwise, I'm going to go over to J&J and
Yeah. Is there anything else you'd like to add before I make the ruling?
nope,
All
that's
right.
it.
Thank you. All right. I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 26th, which is 30 days. In the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm going to admit the case file and PowerPoint as exhibits into evidence, and I find the notices properly given in this case. So please stay in contact with Mr. Schaller, so he's kept up to date as to your, all the efforts you're making towards compliance.
Yes, ma'am.
Thank you. All right, the next case is DEL 25-083, 667 Killian Circle. Oh, there you go.
Good evening.
Good evening.
My name is Josemar Jimenez. I am employed by the City of Deltona as a code compliance officer. This will be case number DEL 25-083, the City of Deltona versus Lissandro and Grace Perez. The property address is 667 Killian Circle, Deltona, Florida, 32738. The parcel ID number is 813-019-040-010. This is a violation of the City of Deltona Ordinance Section 18-3, adopting the latest edition of the Florida Building Code, Section 105.1, which states that any owner, authorized agent who intends to construct, enlarge, alter, repair, move, demolish, or change the occupancy of a building or structure, or to erect, install, enlarge, alter, repair, remove, convert, or replace any electrical, gas, mechanical, or plumbing system, the installation of which is regulated by this code, or the cause of any such work to be done, shall first make an application to the building official and obtain the required permits. The corrective action for said violation is to obtain a permit for the deck. Applications must be submitted to the City of Deltona. The structure must meet all requirements of the city and to be approved on final inspection. The statutory requirement for notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they were taken. This case originally was opened on January 30th of 2025 by a different officer, where a complaint was made of a pool deck being erected at this location. Upon checking records, the officer noticed no permit has been issued on file with the city. The officer made contact with the resident at this property, a Miss Elizabeth, who informed the officer that the deck was built by a professional company and that a permit should have been applied for by them. Our records showed no such permit was ever applied for. The resident was given time to come into compliance. I took over this case on April 25th, 2025, and went to the location and saw the deck was still present with no permit still issued on file. I proceeded to post a notice of violation, as well as sending it out certified mail, along with leaving my card for point of contact. I was able to get in contact by phone with a company, Lifetime Fence, who was hired to do the engineer drawings for the deck, and spoke with a Linda DeKay, who informed me that an engineer was hired and the drawings are still being processed. I informed her that a notice of violation has been given to the property owner and the compliance date. On May 8th, I received a call from the company informing me that a permit application has been submitted to the city. I then verified with the permitting department that the application was being reviewed. On May 23rd, the permitting department sent a notification to the company that the permit was denied because the city had left notes for the engineer to respond and changes that would have to be made in order to continue the process of obtaining the permit, which were never done. I spoke with Ms. Linda DeKay again from the company on June 6th about the denial, and she informed me that with engineers, it does take time, sometimes a few weeks. I informed her that I understand it is a process with engineers, but that I have given plenty of time at this point, and permits have to be issued in order for the property owner to come into compliance. She requested I give her a few more weeks for the engineer to respond and fix all corrections requested by the city. With the multiple extensions given and no more communication from any party at this point, I proceeded in posting a notice of hearing on August 13th, 2025. I was able to speak with the residents in the home that day, and Miss Elizabeth and Mr. Brown informed me that the homeowner is the son and that they will personally reach out to the company to try to get this resolved. And we were made aware of the special magistrate date. Still today, permit has not been finalized and issued, and the property has not come into compliance. The city would like to request 30 days for the property to come into compliance, or a fine of $50 per day to be imposed until such time that the property owner has notified the city of compliance.
Thank you. You said the last time you spoke with the engineering company was when?
June 6th.
Okay. And there's been no further movement on the permit since then?
Right, I gave from June 6th, and I gave even more time, and yeah.
Okay.
Haven't received anything.
All right. Ma'am, can you state your name and address for the record?
My name is Elizabeth Reyes. I'm at 667 Killian Circle, Deltona, Florida, 32738.
Okay. And you are the mother of the owner? Okay.
Yes.
All right. What would you like to tell me about the case?
I don't know why it's taken so long. We've done everything in our power to get this corrected. Right now, I have Linda from the company, the fencing, Lifetime Fencing company here. Maybe she can give you a better outlook than I can, because I can't understand why I'm going through all this.
Okay.
I mean, the engineer's been paid for everything, and...
So you have a witness you'd like to
Yes,
bring up? Okay.
yes,
All right.
please.
My name is Linda Krukenberg. Do you need my address or the business address?
Business address is fine.
681 South Charles Richard Boulevard, Deltona. I'm sorry, DeBerry.
Thank you. All right, and what would you like to tell me about the case this evening?
There, as you can see, the application for the permit had been submitted.
Mm-hmm.
The city wanted some more information. They wanted some corrections that didn't meet their standards.
Mm-hmm.
It was submitted to the engineer, and there was a miscommunication between the engineer and myself. And so when this arose today, well, it arose earlier, but anyway, today I was able to get in contact with the engineer. I don't ordinarily have much direct contact with the engineer. But I was able to get in contact with him, and I sent him a copy of the violation papers. And so he has contacted me, and he knows now what needs to be done, and he will, I feel sure he will be getting on it immediately. So hopefully, you know, if we can get an extension, I believe we can solve this
Yes.
within, you know, soon.
Okay, that's good. Good to hear. And the city's requested 30 days, so, and, you know, there would be, assuming that you can come into compliance by 30 days, there would be no fines imposed. So, did you have anything else to add before I make the ruling?
No.
Okay, all right, thank you. The only other thing I would mention, I mean, and hopefully it doesn't come to this, but I don't think at least the agenda doesn't say that possible corrective action is removing the structure. I know that's not the ideal situation, but that's also an option for you. So with that, I will go ahead and make my ruling. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 26th, which is 30 days. In the event respondent does not comply by the state, a fine in the amount of, and I'm going to say $25 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I reduced that fine because it does appear that you're working diligently, and I hope that you can come into compliance within that 30 days. I'm going to finally admit the case file in PowerPoint into evidence, and I find the notice is properly given in this case. Thank you.
Thank you.
Thank you, Your Honor.
All right, the next case is Fire 033, 2025, 1200 Deltona Boulevard. Which one is this? 12.
For the record, my name is Samuel Schaller, employed by the city of Deltona as the Assistant Fire Marshal. This will be case number Fire 33, 2025, City of Deltona versus Deltona Wellness LP. The property address is 1200 Deltona Boulevard, Deltona, Florida 32725. Parcel ID is 813-006-000020. It's a violation of City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the most recent edition of the Florida Fire Prevention Code as adopted by the State Fire Marshal. Violation A would be NFPA 1, Chapter 1.7.12.10, which states no construction work shall proceed until the authority having jurisdiction has reviewed the plans for compliance with the applicable codes and standards, and the applicable permits have been issued. Violation.
Mr. Charles, sorry, before you read everything, are we still saying that A through F are all not in compliance?
Yes, Your Honor.
Okay, all right, thank you. Go ahead.
Violation B, NFPA 1, Chapter 4.1.3.2.2.5. Buildings shall be designed and constructed to provide reasonable signage and lighting to identify hazards, exits, means of egress, and other building safety features. Violation C, NFPA 1, Chapter 13.1.1. The authority having jurisdiction shall have the authority to require that construction documents for all fire protection systems be submitted for review and approval, and a permit issued prior to the installation, rehabilitation, or modification thereof. Further, the authority having jurisdiction shall have the authority to require that full acceptance tests of the systems be performed in the authority having jurisdiction's presence prior to final system certification. Violation D, NFPA 1, Chapter 11.1.8. All panel boards and switchboards, pull boxes, junction boxes, switches, receptacles, and conduit bodies shall be provided with covers compatible with the use or conduit body construction and suitable for the conditions of use. Violation E, NFPA 1, Chapter 11.1.2.2. determined to present an imminent danger. Existing electrical wiring, fixtures, appliances, and equipment shall be permitted to be maintained in accordance with NEC 70 in effect at the time of the installation. Violation F, NFPA 1, Chapter 11.1.2.1, all new electrical fixtures, wiring, appliances, and equipment shall be installed in accordance with NFPA 70. Corrective action for said violations is violation A, obtain an issued permit for the newly installed exterior door on the rear of Unit 53. Violation B, install room identification signage on the exterior of the door on the rear of the building containing the electrical panels, labeled electrical room. Violation C, obtain an issued permit for the removal of the fire alarm control panel and modification of the tamper and water flow switches. Violation D, provide an approved cover plate for the junction box and water flow switch. Violation E, provide a neat workmanship-like manner for the remaining telephone, low voltage, and electrical wiring resulting from the removal of the fire alarm control panel to remove all wiring no longer in use. Violation F, provide an approved junction box for the exposed spliced wiring going to the water flow switch. Statutory requirements for notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what was observed on the day they were taken. On February 2nd, 2023, Fire Safety Inspector Jerry Bailey conducted an inspection at this location. During said fire inspection, he observed a door leading to an electrical room missing signage and an exterior door that was installed without a permit. Follow-up inspections conducted on March 8th, 2023, June 7th, 2024, December 19th, 2024, March 31st, 2025, June 27th, and July 28th, 2025. Found the violations still in place, no corrections made or permit issued. Permit BLDC 250060 for the replacement of the exterior door was applied for on July 23rd, 2025, and has been ready to issue since August 4th, 2025, but is yet to be picked up and issued.
So violation A, it just hasn't been picked up.
That's correct, Your Honor.
Permit. Okay, go ahead.
July 29th, 2025, while conducting a site visit for a tenant at this location, Fire Safety Inspector Bailey observed the fire alarm control panel, which was monitoring the fire sprinkler system serving suites 40A and 40B to Crunch Fitness and the Family Health Source, removed. In addition to modifications done to the monitoring of the fire alarm sprinkler system's tamper switch and water flow switch. Work appeared to be left in an incomplete state, numerous covers and junction boxes missing. Due to the gravity of this violation, no longer being sure of how a fire sprinkler system serving a pretty large place of public assembly and a healthcare clinic, that's why this portion of the case was also immediately referred to the special magistrate hearing. There was a permit, Fire 250051 was applied for this work on August 21st, 2025. However, a completed permit application was not attached in the submittal, therefore it's unable to be processed. Staff has had communication with property manager, Mr. Mather, regarding removing this fire alarm panel and altering the monitoring of the fire sprinkler system to the fire alarm control panels that serve the individual occupants. However, it was iterated numerous times that a permit would be required prior to this modification happening.
So that was, so, sorry, I'm trying to keep up. So the permit for violation C was submitted but incomplete.
That's correct, Your Honor.
Okay. And you said there was, this one was brought directly to me without providing a notice of violation?
We provided a notice of violation and notice of hearing.
Oh, you did? Okay. Okay, go ahead.
In closing, staff would like to request 14 days to come into compliance with the violations or a fine of $50 per violation per day until such violations are corrected.
Okay. For violation E, this is the one about basically maintaining the electrical wiring in accordance with NFPA 70 in effect at the time of the installation. Do you have any information about the NFPA 70 at the time of installation?
Your Honor, I don't have that copy of NEC 70 with me. However, seeing as this, actually we have the picture right here of it. There's 2 yellow circles surrounding the wiring that was altered. Seeing as this wiring was altered, and it also does present potentially an imminent issue of a fire alarm system not functioning, that's the code that was cited. However, due to it presenting the imminent hazard and it being altered, we fell back to the most current edition of NEC 70. However, I can assure you, I've gone
But it's
through.
been altered, yeah, because it was recently altered.
Yes, Your Honor. I did go through every single edition of NEC 70 that I could get my hands on. Every single edition, going back to the 1990 edition that I have, all requires wiring to be maintained in a workmanship-like manner.
That's the language from the NFPA, okay.
Yes, Your Honor.
All right, and so you're saying that at this time, you don't know whether the fire protection system is actually functional?
We're not sure if the devices are functional anymore. On some of the pictures, I could even walk you through the wiring and what brought that into question.
You can briefly do that, yes.
So right here, this is violation F, but it's also connected to the fire alarm system. This was a water flow switch. It appears someone has altered the wiring that's going to it to the panel that it sends signals to.
Oh, to the panel that sends signals in the event of a fire being detected?
Yes, Your Honor. It's a two-sided switch. I'm not familiar with this exact brand of water flow, but this side generally will go to a 120 that sets off a bell on the outside of the building. And then this side here with the red and white wirings is the low voltage side that sends the signal to the panel to let it know water is flowing, we have an issue. Panel receives a signal, interprets it how computers interpret signals, and sets off the fire alarm system.
Okay.
So you see it's missing. There should be a large red cover of it to where none of those connections, the paddle should be visible, and then the connection itself should have been in a junction box.
Okay. All right.
And then on the that way to E. Yeah, here are a few pictures of the wiring that was left inside the panel. Go to the next one. Thank you. Again, this is the other side of the panel. They actually left the physical metal housing for the panel there, but they removed the motherboard.
Oh,
So
I
it's
see.
basically just a really expensive piece of metal housing now.
Okay.
Yeah, next picture. Here's an overall picture of all the loose wiring left remaining in place. Go to the next picture. I apologize. Go back to D. The picture labels violation D. Thank you. And then here's a tamper switch for the fire sprinkler system. Also appears to have been modified. They left all the low voltage wiring hanging out. Appears to also have been altered.
All right, thank you. Sir, can you state your name and address for the record?
Good evening. My name is Michael Mather. I'm the owner's representative, and I'm at 2837 County Road 776 in Webster, Florida.
All right, thank you. What would you like to tell me about the case?
We are not in argument with any of the violations or the corrective action requested. It's my understanding, it's probably not really relevant to the timing on this, but Mr. Schaller suggested that that permit was issued August 4th, but we haven't picked it up yet. I only just today received a notification from the city that the permit was available today. The confusion might be that the permit was approved, but The contractor had to update his insurance license information, and that took a little time for, I think, his insurance company to get that properly done. So it may have been approved, but not technically given notification that it's available, but I'll simply pick that up tomorrow.
Okay.
The company that we've engaged to do all this other work, it's my understanding they actually completed most of this on Monday or Tuesday. They were held up on the permit by waiting on an affidavit from the owner authorizing them to pick up these permits. That affidavit became available this evening, so I'll be filing that tomorrow. So I don't think there's going to be any problem. The only thing I will say for the record is I've attended an unfortunate number of these hearings, and I've never heard of 14 days.
Mm-hmm.
So I don't think that's going to be a problem, but I want to state for the record that it seems to me that 30 days is a little bit more justified. But I'll acquiesce to your decision.
Yeah, I guess I'll have the city comment on that. I'll go ahead and let you comment on that request.
Your Honor, I'm not sure if you're familiar. These are both repeat violations. And I'm sure you're well aware of the provisions of Statute 162 when it pertains to repeat violations and the imminent fine. So staff was willing to work with the property owner and give them 14 days instead of requesting the immediate fine for the repeat violations. But this being a fire sprinkler system serving a pretty large place of public assembly, it's a gym, has an occupant load of 400 or 500 people, and then a medical clinic. That's why we're requesting the 14 days and would like to stick to it.
All right.
Can I add to that comment?
Yes.
This building used to be, I believe, a Winn-Dixie, and that fire riser room served one entire building. Since then, that building was split into 2 units. Each unit has their own fire alarm, active, and to my knowledge, certified fire alarm panel that is shown to be working. So I don't really believe safety is an issue here. It's been more of a conversation back and forth for a long time about whether that panel in the rear is necessary to the system, whether it should be removed and all that. We were finally able to get cooperation between the 2 tenants. So as owners, we do have a little bit of a handcuff waiting for them to try to get some cooperation until we're justified to step in and take over the issue. I absolutely respect what the fire department is doing here. They've always cooperated with us. And again, I don't anticipate a problem with 14 days, but I just want to say for the record that, yes, it's been a long time, but I don't believe that there's been a real true safety issue here. So I think 14 days is a little punitive just for the record. But I'll accept whatever you guys want to do.
Are there, so are you saying, sir, that there are working fire alarm systems that are separate for each tenant now, and that's not being shown in the pictures? Is that essentially what you're telling me?
That's exactly what I'm telling you. That they are operational panels. They are being monitored by a professional service, and there's been nothing to show that that panel was necessary or that it technically was necessary to remove. We agreed that it just should be cleaned up and removed. It was removed, but obviously there needs to be some wires buttoned up and the panel closed up and some covers placed on. We take no offense from this. We have no argument about whether this should or should not be done. I just wanted to make the record clear about the 14 days.
All right. I think that, and so, Mr. Schaller, which violations are repeat? Do you know which ones specifically?
Yes, Your Honor. NFPA 1, Chapter 1, 7, 12, 10, for no construction work shall proceed. So AHJs review the plans for compliance. And then NFPA 1, Chapter 13.1.1, pertaining to the permitting of the fire protection system.
Okay, can I comment on that? This has been a repeat violation about whether we should or should not do this. And for instance, the first violation about the door, that has been something that's brought to our attention for quite some time. But no work was done on this panel until just a couple of months ago. So this is not something that's been repeated over and over. The work was done without a permit because they were waiting for an owner's affidavit. But I do object to the
Well, I think-
argument
I
that this
actually
has been a
brought
repeat
the
violation.
order from the case. Your Honor, it was
Yeah.
Fire Zest 015-2023, in which this property was found in violation of both those.
Okay. Yeah, so what Mr. Schaller is referring to is not this particular work, but that this property has been found in violation of these sections previously in the last 5 years. And so that's what constitutes a repeat violation. So, you know, under Florida statute, that would allow me to actually impose a fine beginning at the point that the code inspectors found the violation. I'm not going to do that because it wasn't brought to me really as a repeat violation, and that's not what they're asking for, but I think they're saying that that should weigh in on how much time is given to comply.
Fair enough.
And I think given, I understand there's kind of a dispute about whether or not there's functional fire alarm systems in the building. Obviously, I can't, determine that sitting here. But given that safety concern, and that you're not, I know you're concerned about 14 days, but not entirely objecting to it, I'm going to keep the 14 days. And so I am going to do that. And it sounds like some of these, hopefully you can come into compliance, very soon. You're ready to pick up the permits and things like that. So I'm going to do that. Anything else before I make the ruling?
No, ma'am, thank you.
All right. I'm going to find respondent in this case in violation of the city code as charged, and that respondent correct the violations before 4:00 p.m. on September 10th, which is 14 days. In the event respondent does not comply with this date, a fine in the amount of $50 per day per violation will be imposed for each day the violations continue past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm going to admit the case file and PowerPoint as exhibits into evidence, and I find the notices properly given in this case. Thank you.
Thank you, Your Honor.
This next case is Fire 14-2025, a Massey case, 1380 Howland Boulevard.
Evening again, Your Honor. For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This would be case number Fire 014-2025, City of Deltona versus Circle K Stores, Inc. Property address is 1380 Howland Boulevard, Deltona, Florida, 32738. Parcel ID is 813-038-000060. This is a Massey case. Statutory requirements for notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner, the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. Certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for a violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of the Florida Fire Prevention Code. In specific, the Florida edition of NFPA 1, Chapter 1.7.12.10, states no construction work shall proceed until the AHJ has reviewed the plans for compliance with the applicable codes and standards and the applicable permits have been issued. It was ruled on April 23, 2025. Property owner was given 90 days to comply. The property owner did not come into compliance within those 90 days, has been receiving a fine of $50 a day since July 22, 2025. As of today, the property has accrued a total fine of $1,850. City is requesting that the fines continue at $50 per day until such property owner has notified the city of compliance, Compliance is verified by a fire safety inspector.
You said the amount was,
The current amount
Yes.
that it's accrued, $1,850.
thank you. And so this was for, yes, getting a permit for newly installed cooking equipment and electrical, and then there was an interior wall, correct? That
Yes,
was
ma'am.
installed?
Correct, Your Honor.
And so is there a permit, have they submitted an application at this point?
There has been a permit applied for.
Mm-hmm.
I can't speak on what the plan review comments are. I just know it's pending resubmittal after plan review rejected the submittal that was last turned in.
Okay. All right, sir, what would, sorry, state your name and address first,
J.D.
please.
Morton, and the address is going to be 1380 Holland Boulevard, Deltona, Florida.
Okay.
Three things real quick. Unfortunately, the construction company that filed for that permit has removed themselves from the project. Along with the other violations, took over these projects for Circle K. I worked with the fire marshal, went through it on one of the violations on another store. I got pulled off of the project, put on a different project. Recently found out yesterday that in conversation with Fire Inspector Bailey about these violations on here. Circle K was notified about it. We're not going to argue about that. What has happened as of right now, we've reconsolidated everything. The architect and engineering group is with me, along with Circle K, project manager. Our intent is, number one, I spent a great deal of time here yesterday at the building department to get everything that we needed and find all the information that we needed. We found the permitted drawings. We have to resubmit. It has to go through review again. Have to present it to the fire marshal and all of that through the building department. I'm asking for a 90-day continuance to give me at least 90 days because there's going to have to be some fixes done on the permit side because it was issued under Harris Construction Services and they're no longer there. So we have to reapply for that permit, which means I have to get an NOC, get everything else. I can't speak for anything other than that, but where I'm at right now, our intent is to file for a permit tomorrow. It does take time, but we're going to submit what we have. It does take time. It's got to go through there. I need the 90 days because once this portion gets approved and I take the walls out and all of that and show the inspectors and the fire marshal, this is what we have here. There's been some questions brought up from the fire marshal in regards to the equipment. We had to get all of that information also too. The equipment that is shown there and the installation of that. So our intent is to stop the fines. If we can get a 90-day, stop the fines. We're going to work on that along with, and there's several others that I have to take care of. In conjunction and working with the architect and Circle K's project manager, that I've been tasked with taking all of these over. Unfortunately, I got pulled off. I didn't know anything, and I dug my heels in yesterday with the building department, got a lot of information that I wasn't aware of. So.
Well, I appreciate that. However, this is a Massey hearing, which means I've already found the violations. I've already issued a date to comply, which was July 22nd, with a 90-day allowance, which is frankly quite a bit of time. I mean, you've been in the audience, you've heard that we've given some people 14 days tonight to comply. And so I'm not going to grant an extension It's clear that you haven't come into compliance, but you're well on your way. So I just would encourage you to work as quickly as possible. If it becomes, necessary for you, we do have, a lien reduction process that you can request at the end. But, I've already provided my ruling on when compliance was due. So I appreciate that you're working diligently at this point, but we did provide quite a bit of time to come into compliance. So is there anything else before I make the ruling?
Not a problem. We'll take care of it.
All right, thank you. So I'm going to go ahead and find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
This is DEL 25-063, a Massey case, 1713 Concert Road.
Good evening.
Good evening.
My name is Janice Polasek, and I am employed by the City of Deltona as a Code Compliance Officer. This will be Massey case number DEL 25-063. The City of Deltona versus Hector Enrique and Narisara Jutaris Toro. The property address is 1713 Concert Road. The parcel ID number is 813-045-330-050. The statutory requirements for notification of this hearing have been met by a notice of hearing and notice of code violation sent certified mail to the property owners listed at the address with the property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on June 25th, 2025, that the property was given 16 days to comply. The owner did not come into compliance within those 16 days and has been receiving a fine of $50 a day since July 11th, 2025. As of today, the property has accrued a total fine of $2,400 over 48 days. The city is requesting that the fines continue at $50 per day.
All right. Can you remind me, so this was for parking
Improperly parked boat on the side of the driveway?
Yes. And it's still there today?
Yes, ma'am.
All right. Sir, can you state your name and address for the record?
I appear as Hectorino Enriquez Toro de Iberia, living man, ecclesiastical custodian. My private domicile is 1713 Concert Road, Deltona, in trust without the United States.
All right. Can you tell me, or what would you like to tell me about the case?
For the record, please answer this into the file. It's one for special magistrate and one for the state attorney.
Well, I don't accept papers for the state attorney, but if you would
I got one for the special magistrate.
If you would like,
Would I
Mr. Ron,
give this
can
to-
you bring it forward?
For the record, This matter has been transferred into equity jurisdiction by recorded filing. All administrative actions must be frozen. We do not consent to joinder here. This is not a court of record. There is no lawful standing. This property is not residential. Residential is a legal fiction. Our dwelling is private ecclesiastical homestead and domicile outside administrative jurisdiction. Under Article 5, Section 21 of the Florida Constitution, no tribunal may defer to agency or staff interpretation. Any ordinance must be de novo by the text only. No verified claim or sworn complaint has been presented. Without it, there is no lawful case. This proceeding is without lawful foundation. Our business here is concluded. We reserve our rights and remedies under equity, natural law, and constitutional protection.
All right, sir, were you here at the initial hearing on June 25th?
I had sent you a letter saying that I was gonna have a special non-appearance, and you guys never rebutted anything.
I don't recall seeing that letter, but nevertheless.
I'm finished.
Okay, well, I will admit this into the record.
Thank you. Thank you.
Okay. You're not going to stay to hear my ruling?
Oh, because you have to freeze all administration.
All right, I'm going to decline to do that. You will see not me, but City of Deltona can respond to that. Nevertheless, the Florida statutes do provide authority for special magistrates to hear these cases, so I'm not going to speak further on that. I'm going to go ahead and make my ruling. I find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and PowerPoint as shown today as exhibits and evidence, and I find the notices properly given in this case. I will also admit as an exhibit, the papers that he just turned in, which are titled Notice of Equity Jurisdiction, Objection to Proceedings, and Demand for Freeze of Administrative Action. Thank you.
Thank you, Your Honor.
All right. This is DEL 25-049, A, B, C, D, and E, a Massey case, 1197 Acorn Court.
Good evening. My name is Tina Pagan. I am employed by the City of Deltona as a code compliance officer. This will be Massey case number DL 25-049, A, B, C, and E. BLD 25-0267. B is BLD 25-0268. C is BLD 25-0269. And E is LTM 25-0157. D was one of them, but due to a repeat, it's straight for fines.
Okay, yeah, D was a repeat, so it's just the fine is accruing at this point.
Correct.
Yes.
The City of Deltona versus Brian Bromigan. The property address is 1197 Acorn Court Drive, Deltona, Florida, 32725. The parcel ID number is 813-0022-00270. Statutory requirements The statutory requirements for this notification of this hearing have been met by the notice of hearing and notice of code violation were sent certified mail to the property and owner at the address listed with the property appraiser's record. In addition, both cases were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. It was ruled on May 28, 2025, that the property was given 61 days to comply. The owner did not come into compliance within those 61 days and have been receiving a fine of $25 per violation for a total of $100 a day for all 4 cases since July 29, 2025. As of today, the property has accrued a total fine of $3,000 over 30 days. The city would like to request that the fines continue for $25 per day for violation A, B, C, and E, totaling $100 per day.
All right, thank you. So I just have to go through these in order here. So violation A was related to an accessory structure, correct? And there was a screen enclosure?
Yeah, screen enclosure disrepair.
Okay, and am I seeing a picture of that? Oh,
Yeah, that's it.
Is this today?
Today's photo is more down. There you go.
Okay. All right, and then B was collapsing roof.
Yeah, that was the shed. That's it right there.
Yeah, okay. That's the shed?
Yeah, the shed is in the back. Let me see if I could show you exactly where is that.
It's just hard to
Yeah,
see.
it's here. I know because of all the trees and grass
Yes.
growing all around. This is the shed here, it's still there, and there's stuff hanging all around it.
Okay. Is that vegetation?
Hanging? It's gonna be if he don't cut, yeah.
Okay. All right. And then we had C was a fence on the property. Okay.
That's today's photo.
All right. So it is missing.
Still missing panels
yep.
and in disrepair.
Mm-hmm. And then E.
Will be the vegetation state.
Yes. Okay. All right. Thank you. Okay. Anything?
That's today.
Oh, thank you. All right. So is all of this the vegetation in the foreground of this picture?
Correct.
That all is?
That's on his property.
Yes, okay. All right, thank you.
You're welcome.
All right, I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order for violations A through C and E, and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code compliance inspector to verify compliance. I'm omitting the case file and PowerPoint as exhibits into evidence, and I find the notices were properly given in this case.
Thank you, Your Honor.
Thank you. You can put that back together. That would be nice. Thank you. All right, and this is DEL 25-061, Massey case, 2515 Howland Boulevard. Go ahead.
My name is Janice Palasic, and I am employed by the City of Deltona as a Code Compliance Officer. This will be Massey Case Number DEL 25-061, City of Deltona versus Raphael Sells, EST. The property address is 2515 Howland Boulevard. The parcel ID number is 811-500-00100. The statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with property appraiser's records. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day that they were taken. It was ruled on June 25th, 2025, that the property owner was given 30 days to comply. The owner did not come into compliance within those 30 days and has been receiving a fine of $25 per day since July 25th, 2025. As of today, the property has accrued a total fine of $850 over 34 days. The city is requesting that the fines continue at $25 per day.
Thank you. Okay, so this is today.
Yeah, there's a lot of overgrowth and vegetation. It's a wrought iron fence that's basically split in half in a lot of sections. It's rusted. And
All right, thank you. I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. And I'm going to admit the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
thank you.
Thank you. All right, the next case is DEL 25-077A, a Massey case, 597 Fort Smith Boulevard.
Good evening, Your Honor.
Good evening.
My name is Jeff Scott. I'm employed by the City of Deltona as Code Compliance Officer. This will be the Massey case DEL 25077 for violation A. City of Deltona versus Legacy Investment Team LLC. The property address is 597 Fort Smith Boulevard, Deltona, Florida 32738. Parcel ID is 813-403-000-020. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violation sent certified mail to the property owner at the address listed with the property appraiser's record. In addition, both notices were posted at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including photographs, have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed the day they was taken. It was ruled on July 23rd, 2025, that the property owner was given 14 days to comply. The owner did not come into compliance within those 14 days and have been receiving a fine of $50 a day since August 6th, 2025. As of today, the property has accrued a total fine of $1,100 over 22 days. The city is requesting that the fine continue at $50 per day. And this was the commercial outdoor storage.
Okay, so, yes. So, I see an affidavit of compliance in the file, so that was for violation B?
Yes, ma'am.
And that was for the
Dump truck.
vehicles?
Yes.
Okay. And so, remind me, what was the commercial
Yeah,
storage? that
commercial
was being-
equipment, like that's a hydraulic lift right there. And
Okay.
the other today photo it's kind of hard to see it, but he has a tractor behind that permit box.
Okay. All right, thank you. I find respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm admitting the case file and PowerPoint as evidence, and I find the notices properly given in this case. Thank you.
Thank you.
All right, the next case is Fire 019-2025, a Massey case, 1382 Howland Boulevard.
For the record, my name is Samuel Schaller. I'm employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 019-2025, City of Deltona versus EGE Holdings, LLC. Property address is 1382 Howland Boulevard, Deltona, Florida, 32738. Parcel ID is 813-038-000080. This is a Massey case. Statutory requirements for notification of this hearing have been met. The notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits, submitted to the special magistrate clerk to certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. This was initially a case for violation of Chapter 42, Article 4, Fire Codes, Chapter 42-186, which adopts the latest edition of Florida Fire Prevention Code. In specific, the Florida specific edition of NFPA 1, Fire Code, Section 13.1.9, which requires whenever impairments, critical deficiencies, or non-critical deficiencies are identified in water-based fire protection systems maintained in accordance with NFPA 25, shall be corrected in a time frame approved by the authority having jurisdiction. It was ruled on June 25th, 2025. The property owner was given 30 days to comply. The owner did not come into compliance within those 30 days, has been receiving a fine of $50 a day since July 25th, 2025. As of today, the property has accrued a fine of $1,700. In closing, the city is requesting the fines continue at $50 per day until such property owner has notified the city of compliance and compliance verified by fire safety inspector.
All right, so this had to do with a fire hydrant that was not functioning, correct?
Correct, Your Honor.
And so is it still not functioning? I didn't see pictures.
There are no pictures, Your Honor. This was
okay.
based off of a report we received by the fire protection company. If you have your exhibit packet handy, it would
Yes.
be Exhibit B.
Okay. But this was from December of 2024?
Correct, Your Honor.
Okay. And so they were required to have a new inspection, essentially demonstrating that it was functional?
Correct, Your Honor, and then submit the paperwork to us.
Okay, and they haven't submitted anything?
Correct.
Okay. But you haven't inspected it yourself?
No, Your Honor. It states did not flow due to corrosion and did not flow due to corrosion and moisture on bonnet. Recommend rebuild, possibly replace. Reading that sort of throws a flag to me that I wouldn't try and turn that hydrant on myself. They're under a great deal of pressure. If the fire protection contractor isn't flowing it due to corrosion and recommending a rebuild, I certainly wouldn't feel comfortable trying to flow it either myself without being told that it's been repaired and it works.
Okay. All right. I'm going to find that respondent in this case failed to correct the violation by the time specified in the special magistrate's prior order in this case, and the fine will be imposed as set forth in that order and will continue to run until the property is brought into compliance and an affidavit of compliance has been filed by the code compliance inspector. Respondent shall notify the code inspector to verify compliance. I'm omitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case.
Thank you.
Next case is Fire 023-2025, 2135 Howland Boulevard.
For the record, my name is Lisa Nadeau. I am employed by the City of Deltona as a fire safety inspector. This will be case number Fire-023-2025. The City of Deltona versus Scarpello Development, LLC. The property is 2135 Howland Boulevard, Suite 105, Deltona, Florida 32738. Parcel ID is 813-074-000-100. This is a violation of the City of Deltona Ordinance, Chapter 42, Article 4, Fire Codes, Chapter 42 through 186, which adopts the most recent edition of the Florida Fire Prevention Code, as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1, 12.3.3.1, fire resistive construction not maintained, fire barriers, fire walls. Required fire resistive construction including fire barriers, fire walls, exterior walls due to location on property, fire resistive requirements based on type of construction, draft stop partitions, and roof coverings shall be maintained and shall be properly repaired, restored, or replaced where damaged, altered, breached, penetrated, removed, or improperly installed. We're asking that for them to provide the UL system that was utilized to repair the damaged fire-rated wall in this location. Statutory requirements for notification of this hearing have been met by the notice of hearing and notice of code violations were sent certified mail to the property owner at the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case includes the photographs, which have been marked as exhibits and submitted to the special magistrate clerk. I certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. On January 7th, 2025, I conducted a fire safety inspection at this address where I observed unprotected penetrations in the firewall between the stockroom and storefront. The property owner was notified in writing of the violation and given a time frame to correct said violation. A re-inspection was conducted on March 19th, 2025, and found the penetrations were sealed, but no UL details were provided for how the penetrations were sealed and protected. This information was requested from the business and property owners. Subsequent re-inspections on April 11th, 2025, April 29th, 2025, and May 8th, 2025 found no progress on the noted violation and no UL details submitted. Upon today's visit, no progress was made on the violations. The city would like to request 30 days for the property to come into compliance with the remainder of the violations or a fine of $50 per day until such time that the property owner has notified the city of compliance.
Okay, so this is, what kind of business is this?
Right now it is a mercantile.
Okay, and, okay, and then there's, oh, I see. So these are like patches that were filled and just, you don't know essentially what material was used to fill it?
No, we don't know if it was repaired to UL standards for a firewall, for a fire.
Yes, okay. All right. I will go ahead and make the ruling. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on September 26th. In the event respondent does not comply by this date, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. Respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you.
Thank you.
All right. Fire 036-2025, 1878 Providence Boulevard.
For the record, my name is Samuel Schaller, employed by the City of Deltona as the Assistant Fire Marshal. This will be case number Fire 36-2025, City of Deltona versus Fast Lane 1878 Investments, Inc. Property address is 1878 Providence Boulevard, Suite T, Deltona, Florida 32725. Parcel ID is 813-0151-60060. It's a violation of City of Deltona Ordinance Chapter 42, Article 4, Fire Codes Chapter 42-186, which adopts the most recent edition of Florida Fire Prevention Code as adopted by the State Fire Marshal, which contains the Florida-specific version of NFPA 1 Fire Code, Section 1.7.12.8. Authority having jurisdiction shall be authorized to require permits for conditions listed in 1.7.12.2, 1.7.12.5, 1.7.12.6, unless otherwise permitted by 1.7.12.9. Corrective action for said violations is to obtain an issued change of occupancy permit. Contact our office with permit number once obtained. Statutory requirements for notification of this hearing have been met. Notice of hearing and notice of code violations were sent certified mail to the property owner, the address listed with the property appraiser's records. In addition, both notices were posted on the property and at City Hall at least 10 days prior to this hearing. All of the evidence in this case, including the photographs, have been marked as exhibits and submitted to the special magistrate clerk. Certify any and all photographs to be true and accurate portrayals of what I observed on the day they were taken. March 27, 2025, while conducting a fire safety inspection at this location, Inspector Jerry Bailey observed and determined that the use of this suite had changed from its previous occupancy classification of business to now being utilized as a mercantile occupancy. Business owner was informed that a change of occupancy classification permit was required. During follow-up inspections on May 5th, June 3rd, June 30th, and July 28th, 2025, no change of use permit had been applied for in the space still in use as a mercantile occupancy. On August 15th, 2025, change of occupancy classification permit was submitted, but was rejected due to an insufficient submittal. In closing, the city would like to request 45 days for the property owner to come into compliance with the remainder of the violations, fine of $50 per day until such time that the property owner has notified the city of compliance.
All right. I guess, sort of out of curiosity, is there much of a difference between business and mercantile as to what they would need to do to obtain that?
To actually obtain the permit is relatively easy. They just submitted a drawing, a scaled drawing of the space, showing a general layout of it where merchandise will be, fire extinguishers. The biggest factor that comes into play is the wall right there on the left. It's a tenant separation wall. The fire rating of it may come into play with the change of occupancy.
All right.
But we don't know that until, we get the full set of plans to be able to look at and determine that.
Right. Okay. And then can you help direct me, so it says the AHJ shall be authorized to require permits for conditions listed in, and then multiple sections. Which section are we looking at here?
Your Honor, it would be section 1.7.12.5.
Okay. That's for change of occupancy.
Correct. It states, and I'm sorry, I'm reciting this off memory of the code book, but it states that plans shall be submitted to the AHJ prior to the change of occupancy in any building. And then 1.7.12.8 further expands on that by saying we can require a permit for that.
All right. Thank you. All right. I will go ahead and make the ruling. I find respondent in this case in violation of the city code as charged, and that respondent correct the violation before 4:00 p.m. on, this is actually 47 days because of the weekend, so it would be October 13th. In the event respondent does not comply by the state, a fine in the amount of $50 per day will be imposed for each day the violation continues past the aforestated date. The respondent is further ordered to contact the code compliance inspector to verify compliance with this order. I'm admitting the case file and PowerPoint as exhibits, and I find the notices properly given in this case. Thank you. All right, that's all the cases? All right, anything for the good of the order before we adjourn? No? I will sign these. I do have a couple of minutes here from June and July that I will sign. Otherwise, we're adjourned.
Thank you.
Thank you.